I'll let you know when we're up and running. You know when we're up and running. Alrighty, welcome to our Common Estate Planning Mistakes webinar. We have our wonderful host, Kevin Snyder here. Thank you all for attending, and thank you for those who are jumping in. We'll give it just a few minutes so that way everyone can get situated here. As per usual, we are going to be recording this webinar. We are going live on YouTube, so you're welcome to view it that way. But we will be recording it so that you all will have it in your inbox. So those of you that have registered, we will be sending out the recording and the slides. And if you haven't registered, feel free to reach out to our team. We have our contact information on the screen right here. I'm happy to get that over to you after today's webinar. We're just going to give it a few more minutes and get situated here. But just want to disclaim, if you have any questions as we're going through, please feel free to drop them in the chat. We will have a dedicated Q&A session at the end. However, I encourage you to drop in your questions when you have them. I know myself, I forget as we're going through. So feel free to do that. So we have those. I'll do my best as we're going through to answer any questions you may have. But again, we will have a dedicated session at the end for questions. So if I can't answer your question, we will get to it. And if you have to hop off, no worries. Still drop your question in there. We'll make sure to reach out to you so you get your questions answered. And if there's anything else you need as we're going through, again, just drop it in the chat for me. If you have to hop off, no worries. Still drop your question in there. We'll make sure to reach out.
Yeah, Laura, also for those on YouTube, if they're, I know you have YouTube queued up, and so if you're watching live stream right now on YouTube and you have a comment or question, you can put that in the comment section on YouTube, and Laura will pick that up and transition it into this live stream here, so we'll cover it.
Yeah. All right, well, in an effort to stick to our allocated time, I say we get going, and those who pop in can pop in, and we'll just begin.
Sounds great. So welcome everybody to Friday Lunch and Learn. It is an opportunity for us to share with you and download in a fairly brief fashion, an interesting way, some of the things that we've learned in the last 10 plus years of our practice in this area. Common estate planning mistakes is a favorite of mine and a favorite of our just our universe because there are so many things that can go wrong with an estate plan, right? It's basically like a fancy car, a car that you build, and if it's not maintained well, then it could break down if we don't choose the right driver. It could be driven into the ground or crashed. If we don't build a car, then we can't get anywhere. So we're going to kind of talk through that today. And I'm going to use analogies like our car, building a house and things like that. Why? Because I'm a visual learner. And most people are, and sometimes I know in other areas of life, I get overwhelmed and shut down a little bit mentally. If things sound too complicated, then they sound a little overwhelming, and it sounds like it's going to take a long time. And then what do we do in those situations as humans? We put it off. So, and hey, I have plenty of procrastination examples in my own life. We all do. We're human. So my job and our team's job and it is to try to break this down so it does not feel so overwhelming, so that you can take that action step that's going to be helpful for you and your family, whether it's with our office or you have an attorney already, or if you're zooming in from other states. This is a California specific webinar, but a lot of these concepts are also concepts that are similar in other states. Just a caveat, because I am aware and I'm beholden to the State Bar of California, so I have to say the little quick disclaimer, you should have a consultation with an estate planning attorney licensed in the state that you're in. Good news is, if you're in California, we're licensed here. Great, you can have that conversation with us. If you're in a state like Tennessee, good news, we're getting licensed there too. So hold on to your horses. And if you have horses in Texas, we're getting licensed there too. So we can field those questions from those states about other states. Talk to a licensed professional there. If you don't know one, guess what? We know a lot of people. In 10 years, we have a wide network across the country. Reach out to us. We'd be happy to make a referral. All right, so let's dive in to all the interesting things we're going to talk about today. I want you to see what you're going to learn. Well, of course, here's the page that says, I know what I'm talking about, right? That's me from a few years ago when I didn't have the goatee. But really, what I want you to draw out of this page is just know that I'm a real person. I'm a husband, father, and attorney. I'm passionate about families, passionate about legacy. I'm passionate about making sure that people are well situated. I went to school for it. I've been to school for a long time. I've been practicing for a long time. It'll be 20 years in December. Hard to believe that that's come around. So I've seen a lot. And I want to share the knowledge and experience that I have because I really, really enjoy making our community a better place. So why am I going to hog that? I want to make sure we share it. So that's what this page is all about. If you want to digest it more, you'll get the slides. You go on our website, you can take a look. And here's my beautiful family. So yes, I'm a real person. I have married to a wonderful wife, Carolyn. We have three wonderful children. I have my own parents and my in-laws, and we have sisters and brothers-in-law, nieces and nephews, and just like anybody, right? So what I'm talking to you about today, a lot of it's professional experience, but it's also colored with personal experience. So things that keep me up at night, maybe keeping you up at night. And if you're in a demographic, whether you want to call yourself the squeeze generation or the sandwich generation, you have older relatives that you're worried about, you have a family at home that you're worried about, then you know what? That's my reality as well. I get you, particularly if you're a business owner. I definitely get you. But these things are super important on my mind and my client's mind. So we're talking about this on a daily basis and want to share that with you. So here's what you're going to learn. Here are the 10 topics we're going to cover today at a high level because we only have so much time. And if we break it down, I have about 5 minutes per topic here. So that's hardly enough. But the whole idea is for you to get a flavor, for you to just see and understand, like, hey, does this apply to me? And get you a little nugget of knowledge. And so that hopefully that sparks and spurs you to take a positive action step forward. Oh, here's one of my favorite analogies, and it's such a favorite of mine. I wrote a book about it, and you can find that book online on our website. It's What's in Your Wagon, and it's all about this family wagon that we have when we do estate planning. Whether you're married like this couple up here, whether you're in that retirement age of your life like this couple here, it doesn't matter. It could be an individual walking on the road. The fact is, we all walk a road of life. Along that road of life, we acquire things that matter most to us. Now, if we were to think about those boxes like here, like this gentleman, we are just acquiring them and balancing them during our life. It's kind of tenuous as we walk through, right? As we add things on, it's not as easy to balance the boxes. Everyone has different boxes. A lot of these are similar to some of you. But as we go on, our challenge is keeping them upright and balanced. And here, if we're able to walk on two legs, we can manage it, but what if we can't walk on two legs because we've fallen down? When are we going to fall down in life? We're going to fall down in life when we step into a pothole of life. Accident, injury, or illness, death, lawsuit, divorce, um, high taxes, bankruptcy. These are things that commonly happen to people, one or all of these things in life, and they can really derail you. Why? Because if you fall down, you're no longer able to balance the boxes. It spills out on the road. Things are broken, things spill out, and guess who cleans them up? The court's cleaning crew. That's right. Probate court's going to come in with their cleaning crew. That's going to cost your family money, and they're going to do it their way. So it's not advantageous for us to walk through life balancing things tenuously, hoping that we don't fall down and make it, so we don't create this mess. we know the longer that we live, that we're going to at least step into the pothole of disability as we age, become infirm, and a lot of that's cognitive. That there's going to be these incidents that disrupt the balance. So instead of having a disruption, we create a wagon, this radio flyer wagon here. If you come to our office, you get to see the real deal. My great dad gifted me his from when he was a kid, rebuilt it with my 12-year-old, and it's sitting in our office. Wooden radio flyer. And I don't even make, I don't know if they make the metal ones anymore. They're plastic now, but I have the wooden OG one in the office. It's super cool. And that's a legacy. So we'll tie that legacy concept, put a pin in that. Stay tuned for later when I bring up legacy again. So you were going to instead create a wagon that we're going to put all the things that matter most to you in the wagon, and we're going to wheel the wagon down your life so that when you do step into a pothole, there's no balance disruption. You fall down, unfortunately, but nothing spills out of the wagon because you're holding the handle, so you just drop the handle. And you designate a person to pick up that handle and wheel the wagon down the road of your life where you want to go. Nothing disturbed. So that's what we're trying to do when we're doing estate planning. Now, there's a variety of tools that we use to build this wagon. You've heard them: trusts, powers of attorney, wills, pour over will, advance directive, revocable trust, irrevocable trust. Well, you've heard all these things, but these are just tools, right? And tools are similar. And if we just think about building something like a house, we have a saw, a hammer, we have screwdrivers, we have wrenches. These are common tools that every a carpenter or person building contractor uses to build a house. However, not every house looks the same, right? So we use similar tools to build different things. And that's exactly what's true with your estate planning. We're going to use these tools to build something unique to you. So when you're looking at it and you're hearing, oh, I need a trust, that's just a tool. But how that trust is built is going to be particular to your family. And we'll talk about being wary of those online tools in a moment. And what are we trying to avoid in a lot of this? Like I mentioned, the courts cleanup crew, that's probate court. And we're in October. It's a month of scary scaries. And I can't think of a scarier thing than probate court. No joke. I'm not trying to be glib or funny with this. Well, maybe a little funny, but it is scary. It's scary because it's going to be an unknown to your family. It's going to be challenging in some regards whether people are fighting or not. It's going to be challenging and scary, lengthy, and cost a lot more money than you realize. And that's because probate comes into your life in a variety of different ways. So let's go back to the potholes. So number one, you pass away, you die. That's a pothole of death. Well, guess what? If you're a Californian, your estate's going through probate probably 95% of the time. And that's probably being conservative. It's probably higher than that because most of us own real estate. And the laws in California are such that, and actually, you know what? The laws change so frequently that this slide is actually needs a little bit of an update. See that number there, 184,500? That was the old threshold. The new threshold is a whole whopping $208,850, so not much higher. So if you have assets of fair market value above that number and you pass away, even with a will, because you did that earlier in life, you did that in another state and moved here to California, then your family's in trouble. They still land in probate. So certainly if you haven't done any planning, land in probate. But even if you have just a will, probate. If you have a house, your primary residence, and it's worth more than $750,000, probate. So I don't know about you. Most houses in Southern California are north of that figure. So it is very easy for somebody to land or have their estate land in probate. Oh, but Kevin, I own my house with my wife and my husband. Well, guess what? We're going to talk about that in a second. Conservatorship is another place where probate happens because it's in the probate court, and that's when you can't make decisions for yourself. And now someone has to be legally appointed to be your conservator. Yes, even your spouse has to have that legal appointment through a conservatorship proceeding if you haven't done your planning. There's no automatic rights for married couples. That's conservatorship. Guess what? That's probably more expensive than dying without a plan because there are multiple parties that need to get paid. The court gets paid. Your attorney, if you're applying for to be a conservator for a loved one, gets paid. The court appoints your loved one an attorney. That attorney gets paid, and there probably is going to be a guardian ad litem that gets appointed for your loved one. That guardian ad litem gets paid. And so it's a super expensive process. Every court appearance is super expensive because four entities or people are getting paid out of that. So we want to stay away from that. Same with guardianship. Guardianship is basically a conservatorship for children, but all the other lawyers out there saying, wait, no, it's a little different. Just conceptually, we're asking a court to appoint somebody to have the responsibility to take care of a child that's under age 18. That's a guardianship for minor children and also expensive because your child gets an attorney, your child gets a guardian ad litem. Same situation, super expensive. Um, and just for you to be for somebody you know to be appointed, not you if you're the parent, you have parental rights. But and let's say you married somebody who had kids, young kids, and you did not adopt them, then you're going to need a petition to be a guardian if your spouse passed away, if you wanted to be the legal guardian of their children. It's things to think about. We want to avoid probate. Probate after death, which is the common one we talk about, is super problematic because of all these reasons here. It's long, a year and a half or longer. You don't control anything because the person in the black robe, they're in control, and their little minion, the probate referee, is probably the most in control because they're the boots on the ground for the court and making recommendations for the judge. It's public in nature, so anybody can show up, whether it's your creditors or your family, friends and looky-loos can come. People who are opportunistic can show up and get information about your estate and file claims. There's whether they're righteous claims or not, they can still file them, and your state has to deal with them, and that slows the process and makes things more expensive. There's no asset protection, meaning two things: that if there was a lawsuit, say you got in a car accident and it was your fault and that killed you, and but it also injured other people, well, your assets are exposed to that lawsuit even after your death. Your debt doesn't necessarily die with you. I get asked that about loans all the time, student loans. That's not necessarily true. So your assets aren't protected from creditors of your debt. Then we have the 18-year-old problem, the meaning that your children, minor children, if they're under the age 18, this becomes a very expensive process because it remains open not for a year and a half, but until the child turns 18. That means they have a guardian ad litem and a person, a fiduciary that's appointed, both of whom get paid over the years to make sure that your child is taken care of from a financial perspective and their money's managed well. And then at 18, they get a big fat check, publisher clearinghouse check, and use it or lose it. I don't know about you. When I was 18, I was in no position to be handling even hardly over a couple hundred dollars because I'd probably go spend it on CDs and concerts at the time. So do we want our 18-year-olds to be receiving larger amounts of money? No, we don't, because they're just not mature enough yet to spend it wisely and know what decisions to make with that. And it's a negative attraction. People find out, oh, so and so just inherited a bunch of money. And you have these leeches or people who are persuading, let's do a big house party, things like that, that could land your children in a lot of trouble. And it is expensive because before anything goes to your kids, we have about a 5% haircut off of your estate that goes to the lawyers, the court, and the executor. Those are the fees. So the lawyer gets 2.4% on average of the estate. So think about $1 million estate, a kind of pedestrian average estate these days in Southern California, just a house can be $1 million. That's $24,000 in legal fees just to transfer the house through probate. It's statutory, no negotiating. So it has to happen at the close of probate. So that's an expensive way to pass your house to your children or your grandchildren. $24,000. That's you can do your estate planning for a lot less than that. So I talked about probate and why we want to avoid it. So the first mistake in all of this, as we get to it, now that we have that understanding of some of the problems, we don't want the court involved in our life. If we spill things out, court gets involved. We don't want that. So we got to do some planning. But mistake number one is the wall of like, I'm not wealthy enough to do planning. When I get wealthy, I will do planning. Guess what? You have stuff to plan for, and people to plan for, because it's not just all about dollars and cents. It's about people. Remember, it's about family. We don't want our family to be put through the court system when bad things happen to us, whether we're alive or we've died. Alive? What if we get in a car accident and we're in the hospital unconscious or heavily sedated for a period of time? During that period of time, we can't do anything. We can't pay bills. We can't manage our life. So we need managers in our life. If we don't have them, then our families got to go to court to have the court appoint them. We're in a conservatorship. So it's not about being wealthy. It doesn't matter how much money I have. It matters access, permission. That's what matters. The ability to care for, make decisions. That's what matters. Nothing to do with money. But guess what? It's going to do a lot with money because it's going to cost money to do that. But it's not because you have money. You can have $0, and that's still an issue because if you go down and you're not able to make decisions anymore, then someone's going to have to go to court, and that's going to cost your family money to do that. So it's not just for the wealthy, this is for everybody. I say when you turn 18, you need a plan just as much as you need a plan throughout your life. It's just what type of plan do you need? We're going to talk about that. So it's not just for the wealthy. Oh, we were going to talk about it right now. Here it is. Oh, go back to it. So your house of protection. This really kind of lays out my feelings on this as we level up, as we build our house of protection in our lifetime. When you turn 18, you're at the bedrock. We need to level out the lot. We need to make sure the lot is good, level it out. Maybe we're putting in digging a hole to put that foundation later. We're just getting that prepared. That's your bedrock. Right, so that's our powers of attorney, healthcare directive, and basic will. When you turn 18, need all of those. Then we level up to putting a foundation on that first floor. Foundation and first floor, for most people, it's a revocable trust because we now have acquired a little bit more things like a house, which, by the way, it's when I throw out numbers like 750,000, that's not equity we're talking about. That's just fair market value. So many people have mortgages and they're like, well, my house isn't worth that to me because I have a hefty mortgage on it, so I only have $400,000 of equity. It doesn't matter. It doesn't matter. The court's going to look at the fair market value. So your $1.1 million house that has a $600,000 mortgage, that is going to get going through probate court at 1.1. That means the attorney's fees are going to be calculated based on 1.1. So we need to have a trust to avoid probate. Asset protection. So as you start to acquire things that might be liabilities, like if you have a rental, an Airbnb, or you have your starter home that you kept that you now rent out to people, or you're more of an investor and you have a lot more real estate that you rent out to get passive income. That creates risk from the tenants, risks from the people coming out of the property and getting hurt. Those can generate lawsuits. And we have what happens with a lawsuit? They're going to come after you and your assets. So how do we prevent that from happening? Maybe it's professionally. You are a lawyer, a doctor, an accountant, a celebrity. You are a target in some fashion for lawsuits, politician. You a sports athlete, you name it. We can go down a list. And in yours, there's a target on you. So you want to make sure that no one can sue you personally in a situation where they want to sue you. Or if they sue you personally, they can't get at your assets and take them away from your family. The biggest one in this area, by the way, has to deal with cryptocurrency. And when people might know that you have a lot of cryptocurrency, now you're deemed as wealthy. So the target is not necessarily you're well known or you have some sort of professional license. You simply get in a car accident. And it happens to be close by to one of those billboards that say, "Hey, Sweet James is here to help you." And they're talking about the person that you injured in the car accident. They hire Sweet James. Sweet James is not so sweet when you're on the other side. He sues you for everything you're worth. We need asset protection. because that situation is very probable if you've ever driven on a freeway in California. And we're litigious society. Tax planning for those that have assets that are over a certain threshold need tax planning. So now we're talking about wealthy, but it's not just about estate taxes. It could be income taxes, which comprise of capital gains taxes, or property taxes. If you're in California and you own property and you want to leave it to the next generation, we got to talk about property tax planning because the law changed in this area. There is for effectively no parent child or grandparent grandchild exception anymore. The property taxes are going to go up. The exception that actually exists is so narrow that it's not even worth talking about right now. So just I want you to not just rely on the thought that there might be an exception. Consider it's no exception and we have a conversation and we talk through it because that can be higher fees. So it's important to have a plan. So the mistake I see number two is that everything's just going to automatically happen. It's going to automatically go to my spouse and my kids. So why do I need a plan? The state's got a plan. It's going to happen that way. Or I've named it beneficiaries. That's another mistake, a related mistake. And so I've already clued in the financial institution or the life insurance company where that money is going. So here's the mistakes and why they're mistakes here. Number one, you don't want the state's plan. You don't want the state's plan because the state is trying to just do a one size fits all plan for everybody. And last time I checked, everyone's family is different. We're all different. So why are we going to take a homogenous plan that might not work? Plus, even if it did, you're like, okay, well, if you passed away and you're married, generally speaking, the next person that gets something is your spouse. That sounds great. Isn't that what I want? It should be easy, but you don't want that to have to happen in a court process, have court just do what you want it to do. You can create a plan that happens outside the court. So we want to stay out of court. It's not going to happen automatically out of court. It will happen in the end, but we've inserted the court process. And remember what I said about probate, lengthy and expensive for the same result. That's bad. And oh, and by the way, it might not just go to your spouse. If you have kids and it's your separate property, it's going to go to not just your spouse, but also your kids. So if you have two kids, it's going to go to half them and half your spouse. If you have more than two kids, it's going to go to where now your spouse is only going to get a third and the kids will get two-thirds. And so there's a lot of results that we would not want in that situation, particularly if we have minor children. So we want to work with that. And what's separate property? Well, look, think about it. If you created a business and you're the only shareholder and you didn't include your wife or husband in that business, that's going to be deemed your separate property. What happens to your shares when you pass away? Whether you it's your company or you are a partner in another company, you inherited something, a piece of property, or you had it before you got married and it's just stayed in your name. Guess what? All that property is your separate property and it is going to be divided between your spouse and your kids. It's not just all going to your spouse. So results you don't want. Beneficiary designations. Um, oh, we're going to wait for that. I'm going to skip over to beneficiary designations slide in a second, but this follows. Beneficiaries might not exist at the time that you pass away. Maybe you and your wife die in a car accident, or you and your husband die in a car accident. Guess what? Your spouse is the primary beneficiary, and you don't have a contingent beneficiary. That asset goes into probate. And if your kids are minors, this is like, well, I have kids. I name my spouse, and I name my two children as the contingent beneficiaries, but your kids are under 18, or at least one of them is. That's going to go through probate too, because the insurance company is not going to pay out to a minor. They can't legally, so it won't. And it'll say, we need instructions from the probate court. So now probate has to be opened in order for your child to benefit from the life insurance. And guess what? That takes a long time, and they're not going to get that immediate benefit that you want them to have. They could be in financial dire straits in the meantime. So we can't rely on beneficiary designations. And the other is if you have a disabled beneficiary, it could be your spouse that has an onset of dementia or a brain injury. That's not going to be helpful to leave it to them, just to their person. They're not legally able to do anything with that. Maybe they're getting government benefits like supplemental security income, SSI, where that will be very disruptive if they inherited that. Or as this past week, we have new clients and where the mom is receiving $1.2 million collectively from her two brothers' estates. Brothers died earlier this year. Mom is on Medi-Cal and she's going to lose Medi-Cal if by inheriting this 1.2 million unless we do some rapid planning before January 1st. So we don't want to operate in this crisis mode, have people being disadvantaged simply because we relied upon beneficiary designations. And the last is, what if the institution loses your beneficiary form? I'm not making this up. It's because this has happened. This has happened where financial institutions can't find the beneficiary designation form, or they only have the older version. They never got the updated one for whatever reason. I have another situation with clients. Mom never filled it out. She didn't fill out the updated one. She had the account and she never submitted the paperwork. She had it, they filled it out for them. She never signed and sent it back. So it's not valid, even though she had it filled out and there was conversations about it. The fact of the matter is that she didn't put pen to paper with a signature means it's not valid. And so it doesn't happen. So all the while, the trust is a good solution. So here is how a trust works rudimentary. I think about it like a box. Some people call it a bucket, a box. It's an open receptacle for your assets. So if we think about the Container Store, makes a lot of money, right? Because we like to be organized. We like to put things in boxes because they're nice and neat and tidy in a box. Trust is the same thing. We're going to create a trust box and we're going to put the assets we want to be neat and tidy with in the trust box. And then the trust is going to have a set of rules that govern what happens with the items in that box at different times in the future when life happens. What happens if you become incapacitated or your spouse becomes incapacitated? You've died, then both you and your spouse have died. What happens with the assets that are in this box? Who's in charge? The trustee, the manager. That's you create this box. You're also the trustee and you are also the beneficiary. You're all three of those roles. But in the future, if you're no longer able to be the trustee, we have to assign someone to be the trustee and manage your assets for you. You're still the beneficiary. You pass away. Now, of course, somebody else is or other people are the beneficiaries, and we need other people to manage for those beneficiaries. Sometimes the trustees and the beneficiaries are the same people. Sometimes they're not. It kind of depends. So this is also an example of a revocable trust. See how the hands going, things going in and out? That means you have access to what's in the box. It looks and feels no different than your personal life now. It's just in this legal box. Doesn't mean you can't use it, sell it, mortgage it. You can do all those things because you have access to the box. And this is what I'm talking about. The rules say, hey, this is what happens to the items in the trust after you pass away. This is an example of a married couple, how things can go. And we have these concepts of shields. These family shields shield our family members or loved ones from negative things in life, like lawsuits, divorces, bankruptcies. And so we can pass an inheritance and have it protected behind the shield. All great things. So mistake number 3 is that trusts are only about what happens upon your passing. So we just talked about family shields and the benefit of having a flow chart essentially for this assets, but it's not just about what happens in death. You need to plan for what happens in life, because if you don't plan for that, your assets could be completely wiped out due to cost of your long-term care or due to a lawsuit or divorce, that there's nothing or little to pass on to the next generation. So we have to do that planning. So we have different types of trusts for these different types of scenarios. Sometimes there's revocable trusts that we were just talking about. Sometimes there's irrevocable or irrevocable trusts that provide some more stronger asset protection. If you're sitting here listening to this webinar and you're saying, hey, Kevin, I'm concerned about lawsuits. I'm worried because I have a young driver that just got their license and they're using my car. They're on my insurance, or we bought the car. Our name's on the title of the car, and they're driving around. And if they get in an accident and it's serious enough where someone gets hurt beyond them, I'm worried that the friends in the car or the other people that are in the other car or cars that get injured, they're going to come after me and they're going to come after my assets as the parent and the owner of the car and sue me. And the answer is, of course they are. Sweet James, like I said, not so sweet, coming after you. Jacob and Ronnie does a good job coming after you. You name the PI attorney, they're certainly going to sue the parent in this situation because the parent has assets and insurance for that matter, but might not have enough insurance, but have enough assets in order to get that for their clients. So we want to make sure we're protected from lawsuits. That's just one example. You're a business owner, you're a landlord because you have a rental property. These are all things that you should be worried about lawsuits because we live in a litigious society and you want to shelter and protect your assets. A revocable trust alone is not going to do that. So saying, "Oh, I have a trust, I have everything in trust. I did a revocable trust in the past, so my assets are protected from lawsuits." No, they're not. Okay, so a revocable trust does not provide any sort of liability shield to lawsuits. You need something different. In addition to, don't throw away your revocable trust, just in addition to that, we need maybe irrevocable trust. We need to look at things like limited liability companies, LLCs, as ways in which to provide liability shields. It's a quick difference, and I'm going to move on because I want to get to some of the other things before we finish. But I also get this question. What you said revocable, you said irrevocable, revocable, irrevocable. Two different types of trust, Kevin. I don't understand. What's different about them? Major difference, one's an open box, you have access. One's a lock box, you have no access or not as easy access. Those are the conceptually the difference. So if you're going to do the irrevocable route, you have to be prepared to be locking assets up from ready, easily available use from yourself. And that's not necessarily a bad thing. It could be the right scenario, but we really have to talk about it. And of course, if you're just using the open box, that's not going to protect you enough in the situations if you're a person that wants to be protected from lawsuits. So we do have to talk about the particulars, but that's just the basic structure of how that all works. I already talked about this, joint ownership and beneficiary designation. The only thing I'll add here is the husband and wife that own a house as husband and wife as joint tenants or husband and wife as community property with a right of survivorship, or you own it with another family member. The siblings own property together. Mom and dad own it with another child. Those are typical scenarios. Or you own it with your loved one that you haven't got married yet. You're dating or you're engaged, but you co-own property together. If you are a co-owner of property and you have this joint tenancy arrangement, then that simply means that you pass away, they get it. And that, hey, that sounds like it works. All right. So husband dies, wife then automatically, without going to court, gets this house. Great. But what happens when the wife dies? If you just rely on that planning, wife doesn't get that doesn't do any additional planning, that wife dies, that house is going to probate. So joint tenancy only kicks the can of probate down the road. I will tell you that most people after a death don't do legal planning right away. Why? They're grieving. Their life's just been overturned. They're in upheaval. They don't get around to doing this. They're maybe thinking about cashing in a life insurance policy and whatnot, but they're not thinking about anything else because everything's okay. Their joint accounts are okay, their house is okay. There's no immediate threat. And that's dangerous when we view it as, oh, there's no immediate threat. This isn't a scare tactic, it's just truth. We don't know, we don't have a crystal ball, we're not promised tomorrow, but it sure feels like we are when we're feeling good and all that. We can kind of implicitly be in denial about that. So, hey, we'll have time to do that. So joint ownership causes problems all the same. Solution, put it in a trust. Do it yourself, online estate planning. So we have LegalZoom. Now we have AI. And so when we also have, hey, you search Google and get some forms online from legitimate sources like a court or they're online. The statute has a statutory advanced healthcare directive and power of attorney. So doing things on your own, is always challenging because you're not an expert in that area. It's bottom line. I just think about it like your pipe bursts in your bathroom and your water's flowing out. Are you going to go on YouTube and figure out how to do it yourself at that moment? No, it's crisis situation. You're going to call an expert. And then the expert is going to tell you that you have old pipes and you should have changed those pipes out years ago. And now it's going to be way more expensive to do that in a crisis moment because you didn't do it. Uh, but if you're trying to do it yourself, you're like, hey, I'm going to get in front of that. And I'm going to go online to YouTube. We're on YouTube right now, right? Tons of stuff on YouTube. So we're going to learn ourselves. Well, the challenge when you do something online with YouTube, right? I don't know about you, but it always comes out looking a little different than it does with the guy or gal on that YouTube trying to instruct me. And so these major projects have major implications. I'm not getting under the house and changing my own pipes. I might be able to do it if I try and watch enough YouTube videos, but I'm not confident that I've done it right, used the right materials. Now I've created a bigger problem. And we see that here in legal planning. Sure, you can do it, you can grab a form, but how do you know you're filling out the right way? And do you really want to take that risk for your family of getting the house with bad piping underneath that dad put in there because he wanted to save some dollars and do it himself and feel all good about it? And it's a false sense of security because dad's not around anymore. Pipes burst and explode, and now you need flooded the house, and now you got to redo the entire house. Or maybe the house is compromised and we got to knock it down. All of that costs a lot of money, missed opportunities. This is the same with the legal planning. So if we have the wrong trust, we have the wrong documents, we have them filled out incorrectly, we have the wrong people in the wrong places because you didn't know about all the other contingencies or the options or the cautions because you never gone through this before, then you're going to have a bad outcome, right? So like I said, it's like building a car. If you're not a mechanic, kind of hard to build a car to be confident that it's going to be able to run on the when you need it to run. And then if you don't know who the right driver is going to be from a legal perspective, then that person's going to crash the car. So AI is, as we've seen in examples, it looks nice, sounds great. We all kind of use it to help in certain fashion, but you got to check. You got to have an expert review things because AI has these hallucinations. There's not really a back and forth. Sure, you can prompt it and you can have these prompting conversations, but garbage in, garbage out mentality. Things that you're feeding it you don't know might be incorrect. And so it's spitting you out an answer that's based on your incorrect information. And so that just perpetuates itself. So having somebody guide the scenario that knows what they're doing is going to offer the best result. And I don't know about you, but I'm just not going to take a chance on my family. So, um, choosing the right decision makers, the drivers of the car. I get asked all the time, how do I choose? Who do I choose as a trustee, executor, my power of attorney? I got my three kids. Do I just name them oldest to youngest and that order? I want to include them all in the decision making. That's only fair. We don't want to leave anybody out. So I'm going to name my two kids as co-trustees or my three kids all as co-trustees. We don't want anybody to feel slighted. Well, there's all sorts of thinking around this, right? So we want the bottom line here for today is just know that don't be flippant about this. You are entrusting a high-powered machine to a driver. So let's just think about if it was your family, your kids are first learning how to drive, do you give them the Ferrari to drive? Right? Do they even know how to drive a manual? So the same concept. Well, you might not want your 18-year-old to be your trustee, right? Because it's too high powered of a machine. Even a basic trust is too high powered of a machine for an 18-year-old to operate. Do you really want your brother, Larry, to be driving that car? Think about it. These are huge responsibilities. This isn't a time for you to comment on how much you love somebody because you've given them a vaunted responsibility. Look, I love you, son or daughter, so I'm going to name you as trustee. That is not a badge of love. That is a lot of work. It's a responsibility. You can be putting them into the crosshairs of future family arguments. These are things, or lawsuits from creditors. They mishandle things. They're not prepared. Uh, Sometimes I look at it like if you don't like your children, maybe you name them as trustees. There are other opportunities. We want our children to be beneficiaries to receive the benefit. We don't necessarily want them to have all the responsibility. We can give that to somebody else who is a professional. There are professional fiduciaries that their whole existence professionally is to be a trustee, an executor, a power of attorney, and some of them also serve as advanced healthcare agents. So they're licensed, they're regulated by the state. They've done hundreds to thousands of estates and administered them. And so they're really good options. Not to say it'd be the right fit for everybody, but something to think about and get more information. So don't just say, I want my kid. I want my oldest and youngest or all of them together. Or if my kids aren't around, then we're going to look at family members. Certainly, if you have minor children, you got to think about who's raising the kids and who's managing the money. Are they the same people, different people? Are there going to be parents? People all going to get along? These are things that you have to consider. Don't just be run through it and be arbitrary and say, hey, this is going to happen down the road. We really don't have to. We just have to put placeholders. We have to consider these plans as going to affect tomorrow. We're planning for today and tomorrow, and if it's a revocable plan, we can always make updates. Revocable trusts are changeable. Powers of attorney can be deleted and superseded. Same with healthcare directives. A will can be changed. We need guardianship for minor children outside of our will. So one of the biggest mistakes is, oh, I talked about who's going to take care of my kids when we pass away. I had the conversation with my other siblings, my parents or parents. We have these great friends that live next door. They have kids. So they're just going to come in and take care of them. So that's just not naturally going to happen automatically. Your parents aren't automatically going to be able to be guardians just simply because they share the same bloodline or last name even. If you are in an accident and then you have your minor kids with you and you're in the hospital and you are still not able to be discharged and you're unconscious or sedated or in surgery, your kids are well enough treated to be discharged. They only got bumps and bruises in this car accident. Who's going to pick them up to get discharged from the hospital? Hospital's not going to keep them. Their parents are going to have to pick them up or a legal guardian. If there's no legal guardian, they call the county, Child Protective Services. They go into temporary custody of the county, and the county will be named guardians, and your family's going to have to rush off, hire lawyers, and go to court to unwind that. It's going to be a negative situation. So you have to have that planned out. Don't just put it in a will. Why? Because in my example, you haven't died yet. My car accident example. So if you have guardians named in a will, doing you no good, doing your kids no good because you haven't died, will's not in effect yet. Might be a validly executed one, but there's no effectiveness yet because you're still alive. So we have to have separate planning. Getting towards the end here, so, I know that's like mistake number eight, but as far as the impact, this is beyond not doing any planning. The next biggest mistake really is not keeping your plan updated and or funding your trust. You create this box and you don't put anything in it. You would be surprised, like, why the heck do you go through the project and by building the box and not put anything into it? The answer life. We're human. Things happen. We get busy. Little Debbie got sick. My mom's in the hospital. Job's really busy. Oh, we'll get to that later. Oh, it's the holidays. We'll push it off to January. We always have an excuse to put off work that looks difficult or might be time consuming or mind numbing for that matter. A lot of this funding is ministerial. So going to the bank, opening up a trust account is probably the number one thing that's not done. Why? Because you got to carve out time to go to the bank and deal with the banker and be there for probably 30 minutes to an hour, filling out forms. And if you're married, you got to be there together. They make it real difficult unless you know a bank that where you can avoid all that and you can do all that remotely. California, Cal Private Bank's one of those banks, by the way. There's others like that. Happy to connect our clients with those great banks and referral partners. You can open up an online account at a bank too. So we're not a brick and mortar places, but online banks hit or miss whether they allow you to have a trust account or not. So we have to be looking at those things. But I have bigger items. You don't put your house in your trust, or you put your house in a trust and then you get it refinanced later down the road. And during that process, they remove your house from your trust for purposes of securing the loan. And you fill out all the paperwork. There's so much paperwork that you miss that aspect that they didn't put it back in your trust, and you just have the stack. You think it's still in your trust, it's not in your trust. You go up and die, and your family says, "Oh, mom and dad have a trust." and find out that mom and dad have a trust, but their house, one of their largest, if not the largest asset they have, is not in the trust. Cue probate. What do you mean? Mom and dad had a trust. Yeah, but the asset's not in there. But it says in the schedule, the house. Yeah, but the title's not in there. So we gotta go to court. And it could end up being a full probate when mom and dad had a trust. And that was the intent. And the screw up, the mistake, was that there wasn't an assurance that the house was still in the trust. See it all the time. And there's a way in which to get around a full probate. It's called a Hegstead petition. And that's like shortcut to a full probate to get a house in a trust, but that's going to cost you $10,000 or more, your family $10,000 or more. So now you've just increased the cost that they're going to have to spend after you die in order to do something that should have been done up front. There wouldn't have been that problem had you just taken some time to look at up the title of your house and make sure it's supposed to be in the right, it's in your trust. If it's not, then use an attorney like us to help you get it that in the trust. Sometimes there's mistakes on deeds and things like that. Or you acquired a new account and you don't do that. You thought you had beneficiaries on your IRA, but you don't. Or they're not connected with your trust. They're connected with your ex spouse, or your brother and sister because you weren't married, you didn't have kids at the time you opened that 401k or IRA or took that life insurance policy out. So there's going to be a whole big mess if you don't get organized. Then we want to get organized. Mistake number nine, we touched on it a little bit already, not having protection against lawsuits and liability, just assuming that a revocable trust is enough, assuming that I have insurance and that's enough, meaning that I have homeowners insurance. Oh, I have property and casualty insurance on my rental property. I have an umbrella policy. I have car insurance. These are all important things to have, don't get me wrong. We're not saying replace them. We're saying that that's just one tool, and that alone is not enough. And we need something more. You need an LLC. You might need an irrevocable trust to provide the shields to prevent some personal liability, prevent you losing your personal assets in a lawsuit, or reverse, losing your investment property because you got in a car accident, Sweet James sues you. Mistake and unknown, this is just not a mistake, but perhaps something that's not widely known. You have property and you live in California, you set up a California limited liability company. Oh, I got an LLC. This is great. Put my investment property in an LLC so that if my tenant or their guests sue, they can't sue me personally. I protect everything that I own. Wonderful. But then you go up and get in a car accident, Sweet James sues you. And you say, wait a minute, Sweet James, you can't come and get my investment property. Uh, yes, Sweet James can, because you have an LLC in California, and California allows for charging orders, meaning that California only offers one-way protection, and that is from the lawsuit is from the property, can't get at you, but if you personally get sued for something not involving your property, like a car accident, those suing you can get at your property. So there's only one-sided protection. We got to look at the right LLCs in other states like Wyoming is one, Nevada, Texas. These are all great states. Delaware is popular. Of course, everyone knows Delaware. You want to start a corporation, people ask, "Oh, should I do in Delaware?" Because it has a history of that. So great creditor protections, business owner protections that offer two-way protections. So you might have the wrong LLC and be operating on this false assumption that you have asset protection because you put your investment property in a California-based LLC. So we need to get an LLC and the right LLC. And the last is don't wait to start. I mentioned it before. We're not promised tomorrow. Not promised tomorrow. We don't like to think that way. It sounds Debbie Downer, all right, but this is just being pragmatic, being honest, and saying, "Hey, I feel great, but I don't know what tomorrow's going to bring." And you just have to go on the news every day to know all sorts of crazy stuff happens every day to people. And we're like, well, it didn't happen to us, didn't happen to someone we know, so that's far, far away. But we just don't know. So whether it's a car accident, a tree falling on you, lightning striking you, you drowning, crazy stuff happens. You having a stroke, early onset of dementia, car accident that leaves you paralyzed, with a traumatic brain injury. These are all things, if we leave our planning to chance, we can't undo some of the challenges once that happen. So it's not, oh, I'll do my planning when I get the diagnosis I have terminal cancer. Some of us don't have that ability to have that moment in time. And even when we get that diagnosis, guess what? We're consumed in the treatment plan. And guess what gets pushed off is our legal planning. I've seen it. I've seen it on people who have bad health, bad situations, and you find out they've died later. And you say, well, they were sick for a while. Why didn't they get their planning done before they passed away? They had time, they had knowledge that there was a strong likelihood that they were not going to make it. We're all not going to make it out of this life alive. They just had maybe a doctor tell them a timeline, but they still didn't plan. Why? Because they're humans and they're focused on something else. Me getting better. I'm going to beat this. I'm going to get better. All important things to have. Hope. We also need to plan for the worst situation, and that's our job is to help plan for the worst situation so you can have peace of mind that that's covered so you can enjoy your life currently. And then if the bad things and the worst does happen at earlier time that you would like or expected, then you have a plan in place that takes care of that, smooths it out for your family, your spouse, your loved ones. It's always going to be a bumpy road to go through those things in life that we don't like to think and talk about, but it is going to be less bumpy. And you're going to want to update that over time. Oh, we have a little bonus, a little gift. And then it's a gift from the IRS and extend on to you. And we can thank the marketing team for this, Lara, in here. So the one big beautiful bill's impact on estate taxes, just as a little aside, this might be helpful for you. January 1, $15 million per person is the threshold. If you have less than that in your estate, you likely don't have to be concerned about estate tax planning. You might still need to if you're young enough and maybe you had 10 million in assets, then maybe we should still talk about it because you have a chance to grow those assets and get over that threshold pretty soon. But also for everybody else, really what that means is the IRS is giving us a gift card worth $15 million, and we can make $15 million of gifts to others in our lifetime tax free. So we don't have to play the game of, oh, well, we can make one gift of $19,000, no more than $19,000 a year to one person, and not have to get worry about get taxed on it. We can play that game if we don't want to report anything, fill out any paperwork. But the reality is, you can gift more than that to anybody in any year. You have the gift card. It's just it becomes problematic if you've used all of the $15 million of gifts. Because at your death, that means if there's any inheritance going to people, that's going to be taxed. So this is a nice little gift for many people, but not that 0.1%, or the 0.2% rather, people. We're still going to need to talk about that. All right, so those are some of the top 10 mistakes that I see. There are many other mistakes that I see, of course, but we got to keep this limited. I'm told we're supposed to keep it to 60 minutes. So I'm landing the plane at technically a couple minutes before we actually started this webinar. So we have time for questions. So fire away. Hopefully, you're getting some good value out of this and there's some questions you might have. So Laura, what do you say? We got any questions that came up? And if not, I know the questions that people are thinking about that they might be shy to ask.
We have no questions so far in the chat or on our live stream, but feel free to either drop them in the box or you can even unmute yourselves if you're on Zoom with us. And
And guess what? If you're on not you're watching this later on YouTube, right? You're like, shoot, I missed the live stream, but I'm watching the video now on YouTube and you have a question. Guess what you can do? You can put your question in the comments. We do look at the comments. We do. I mean,
we do.
she does. And we'll get that question answered. So if you have a question, put it in the comment section whenever you're watching this.
Or if you want to speak to a member of our team, cue the
Even
slide
better.
change. Cue the
Even
slide
better.
change.
Huh. Use slide change. Oh my gosh, how can we help? This is how we can help. You and I are like an infomercial right now. Like, and there's more. And there's
And there's more.
yeah.
And if
So
you scroll to the next slide, you'll see our contact information, other ways that we can help.
yes, so here we talked a lot about planning mistakes, but we do help seniors with long-term care planning, not getting life insurance or long-term care insurance, but planning to qualify for certain benefits because they might not be able to afford or qualify for long-term care insurance anymore. They might be a veteran. They might be qualified for Medi-Cal. If they're not qualified, don't stop there. We can help get them qualified. Someone has died. They had a trust that you need help administering that trust. If they've died without any planning or just a will, we can help with the probate. And then, of course, you have a child that's going to turn 18 very soon or is already 18, is in high school, off in college, grad school, and they don't have that bedrock planning. Guess what? We have a young adult emergency plan for them to allow you as mom or dad or legal guardian to help protect them legally and have permissions legally to get information, financial, legal, medical, or educational information and break through those legal barriers and help them when they're going to need critical help. So here's that slide you were talking about. That is where you can reach out, get a live person, and ask questions, schedule a meeting, and move this forward for you because that is the biggest mistake is not taking action step. Guess what? Don't worry if you haven't taken that action step yet and you knew that you had to do it and you've been saying you had to do it, you've been telling your husband to get moving on this and someone's dragging their feet, it doesn't matter what you haven't done because today's today. Best time to have planted a tree was 20 years ago. But guess what? The next best time is today. So that tree can start growing and once it's planted, it can grow without you. That's the beauty of the tree. So plant your estate planning tree today so it can start growing and grow into that beautiful tree that's going to protect your family and provide that shade from that awful, nasty sun that's going to try to bake your family and give that cool breeze, lots of oxygen and benefits. Fruit. The tree bears fruit. It's a citrus tree. And then that's going to protect your family. So you see, I like analogies and it works. So reach out to us.
All right, we're going to do a last call for questions. I'm sure everybody on this Friday wants to start their weekend a little bit early. So last call for questions.
So one thing that comes up, Laura, in all this, and sometimes in the questions, are things like, "Hey, I think I'm thinking about moving to another state. Should I wait to start my estate planning until I move to the other state?" No. Start it now. Your trust is portable to the other state. Maybe it needs a little tweaking when you move to the other state, maybe not. But if you moved to the other state, did no tweak and you passed away, that's a lot better having that trust in place than not having that trust in place. And maybe you never move. You think you're going to move, but life happens and you don't move. And now we don't want the lack of planning to be there because you thought you were going to do something. Um, Family, things come up. Well, should I include my family? Should I include my kids in my planning? Should I talk to my parents about their planning? Delicate situations. There's no one size fits all, but I will say that good communication goes a long way. Transparency and communication are the biggest solvers of litigation later because people are less inclined to be upset when there aren't any surprises. We're not in the surprise business, right? What we do is not surprise, you have an inheritance, yay! No, people are upset. They're sad. Grief brings out different emotions in people. People process grief at different ways at different times, and it triggers things, and people act differently. And we don't want that surprise to trigger a negative experience. And most likely, it's not going to be a happy surprise. It's going to be a negative surprise. And then, oh, surprise, my brother's suing me. We don't want that type of surprise. We don't want the surprise of, oh, I assumed I was not getting more money, that I was going to get the dining room table. That's mine. Well, I just assumed because we had this conversation in 1985 and things change. And so we want to make sure we're clearing the air about the big and the little stuff.
Hey, we give estate planning and life advice.
Experience, personal and professionally.
All right, well, that's all we've got for today. I just wanted to remind you all who are on Zoom and watching us live, we will be sending out the recording and a copy of the slides as well if you've registered. If you forgot to register, that's completely okay. We have our contact information here. Feel free to reach out. Happy to get you a copy of that. Or like Kevin said, leave it in our comment section on YouTube. Leave it in the chat here. You know where to find us, and we're happy to get that out to you. And if you have any specific questions about your situation or just want to have a longer conversation, feel free to reach out to a member of our team. We're happy to help. We're happy to listen and help you plant those trees.
Well said, Laura. Well, everybody, thanks for your time and attention. Keep being amazing.